Powell, he's in custody. It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation, and it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is
Okay, did you catch that legal landmine? One judge told him to go home, but the official protective order never got updated. That means Mr. Powell was technically breaking the law by obeying a judge. When paperwork lags behind reality, people go to jail. It's wild.
He let a gentleman and this gentleman's girlfriend move in with him. And so
in her house.
In her house with the mom. With the mom. And then the allegation is that the complaining witness stated that he assaulted her on a different occasion, and then that's when the charges were filed. So
complaining stated that Mr. Powell
assaulted her.
Okay.
And then charges were filed, and he was given bond conditions, and at that time, like January 31st, a MOEP was signed. Okay? And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court. He goes back home. He goes back to felony court. The judge allowed him to amend the bond conditions so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD. But the problem was the MOEP was still in place when he went back to the house. So I think it's a violate bond condition and a MOEP. But since that time, I guess, when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom.
And this is the courtroom paradox. She wasn't threatened. She wasn't harmed. But the mere fact that contact occurred, that's the violation. In law, black letter doesn't care if it's a coincidence, misunderstanding, or a roommate grabbing clothes. Rules are rules.
And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right?
Yeah.
So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOEP as well, but the bond condition was removed after it was found the complainant no longer resided at the home.
Holding him at no bond, too.
Right, so.
I don't understand how.
And that's what I'm saying. He does go back to court on the 19th.
No?
For
I
the
mean,
felony.
with our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house, you just can't, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there, because I think the idea is that they don't have communication together.
And I think the
Problem
date
is-
was the February.
And
Yeah.
what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
And according to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOEP that wasn't amended. So,
No,
because that's,
no, but they still are having contact.
Yes,
That's the problem.
Just as,
Not the fact that he's
just as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house. of 40 years.
Right.
Yeah.
Right.
And then she came.
And his mom is a complaining witness.
No,
He's a complaining witness.
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the
one guy.
yeah, one
So
guy.
that's Miss Scott.
Yes, yes.
Yes.
So that's Miss Scott's not.
Not his
not-
mom.
not his
It's
mom.
not his mom.
Okay.
Miss Scott, those are the clothes.
This is where law meets logic, and both lose. Powell was allowed to return after the amendment, but the encounter happened before it was officially changed. He's not a monster's a victim of the timeline, but that still might not save him.
Either, I don't know, I can't tell from the pleadings and what I've read if it was before she was in rehab, after she was in rehab, or during rehab when she goes back over there to get her stuff, because somebody, it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm going to find no probable cause.
We understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case. Powell.
And boom, that's the linchpin. All the paperwork, all the hearings comes down to when that encounter happened. If it was even one day before the court order changed, Powell's in violation. Doesn't matter what was about to happen. It's what was true that day.
Amended.
Yeah.
The MOAB was not amended, and that's what this media is based on. Just to make sure that the facts are being.
And then according
There's
to,
two.
Was that an
different-
oversight on their part upstairs?
it appears
We
so.
don't know.
It may, probably was.
There's no new.
But these bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub, though. They're holding him at no bond upstairs, and then now for another 2 more days.
But the bond is removed.
I'm going to find no PC. I mean, I can't.
This might be one I need to kind of go talk upstairs about.
You want to email them real quick and see?
So
I mean, we have it.
the DVD prosecutor did come down, and basically he was saying, obviously it all depends on the felony, but he also indicated that the MOAB was still in place when the alleged.
Every right to be there because they amended the conditions for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story. Then.
Yes, Your Honor. And so
Say that they amended the condition.
the other case, this is a,
February 14th, and it's August 8th.
Oh.
So what happened is when he went to the location, he got a bond violation, and so he appeared in felony court.
And now we pivot to Mr. Leonard. Another defendant. Another device issue. No car? Doesn't matter. No excuse. The judge lays it down. If the battery dies, so does your bond. In this courtroom, compliance isn't optional. It's survival.
After that, and they amended it.
But he's still nevertheless.
Right.
Your Honor, before, I just asked before
I'm not
a
going to.
decision.
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be
Okay.
there. Right. Okay.
But I was asked if you would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet because obviously he's still doing whatever he wants to do, and I have concerns. Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there, and if they give him a PR bond, and if they're okay with releasing him, then
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
Okay. Yes.
Okay,
So
so we're gonna roll it to the
I
20th.
would say, yeah, Thursday's the 20th, so that we can,
Sounds good. All right, thank you.
I mean, if it was after, I'd find no problem because all day. No.
All right, thank you.
Yeah. Are you ready? It's okay.
Mr. Leonard, shh. So bond violation.
What's the last name?
Leonard. Hold them from Friday. Yeah.
Come up, Mr. Leonard. As of 3/4/25, you failed to get a portable device. When did you get it?
I got it. This is the second one. I had to take my first one because it wasn't registered, just like this one's doing.
So, Your Honor, the long of it all is initially he had an order for an interlock. Doesn't have a car. This case happened. The day of the incident is like years ago. There was an accident. It was a 2B because he was hospitalized in the accident. There was a blood draw, determined that he was over the limit or whatever. So he comes to court and he's ordered to get an interlock, doesn't have a car, tells them he doesn't have a car. There's a bond violation filed.
The first one is because he doesn't have a car, so he just decides not to get a device, right?
No, Your Honor, I believe he was telling them I don't have a car. I mean, in all fairness, I don't believe he knows that he's supposed to then say, hey, can we do the portable or something like that? I don't believe that I don't believe he understands that. I mean, now obviously he does because I think maybe about a week or so later, he was ordered to get the portable device. He went and got a portable device. As there were some issues with the portable device, and that's where this issue is coming in. He was supposed to get it by the 4th. It didn't come in until the 6th of March. And so he's gotten it. I've talked with the pretrial. She said there hasn't been any positive blows on it, but he's still saying that there's, it seems like it's not recording right or something like that.
So let's do this. So I'm just going to put a monitor on your ankle so I know that there are no issues. You know, I'll pay for it, but I'm going to put a scram monitor on your ankle so I know that there are no issues. Mr. Leonard, you must charge this thing on a daily basis. If you don't, if the battery dies, so will your bond. I don't want any more excuses. If you ever have an issue, you have a lawyer. Will go to bat for you, but you can't just not do things because of what you want to do. There are orders in place and you must follow them. And that's it. Any more issues, we're going to have problems. You understand, Mr. Leonard? Okay. All right. We'll continue supervision.
Thank you, Your Honor.
Thank you, sir.
Right this way.
Judge, I've got an off-docket matter asking the court to set bond on a case, please.
Hold on. What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634. 255-4634.
Okay. Give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it?
Yes.
Did you? No.